Today on Off the Clock, I am very excited to have two of my immigration colleagues with us, Lee Ryder-Coffin and Evelina Savitska. They are going to be talking about H-1B season, and in particular, the new modernization rule to make sure all of our listeners are prepared for what they need to do with regard to their H-1Bs.
The registration period for the H-1Bs opens at noon Eastern on March 7th and runs through noon Eastern on March 24th. Now, here is Lee and Evelina.
Well, we are gearing up for H-1B season, and this is a really important time for employers and also international students and talent in the workplace. What the H-1B season is it allows companies to sponsor international students and talent for specialty occupation work visas.
And it's a very narrow window, so it's really good to start thinking about this now and start looking at any possible candidates that an employer might have that they would like to sponsor for this visa.
There's this window of opportunity to file in March. It's only 14 days long to be able to register for a process and get your name in this lottery, which is basically a random process to get selected so that you can proceed to a petition to get your employee that work visa to retain them.
Yeah. And despite the lottery, I always think that the H-1B is a great visa to consider. I mean, it encompasses almost every nationality, many job positions.
And we just want to remind employers, sometimes we get a lot of questions, what's going to happen with the new administration? Well, the H-1B program is alive and well. It exists by statute, and there is a new regulation that's a final rule as of January 17th of this year that modernizes and basically codifies a lot of the previous guidance and procedure is now in regulation. So by this becoming codified in regulation, employers have more stability to anticipate that this is not going to change overnight as would policy interpretation.
Right, and that's something that we definitely experience with any administration change, is when policies were just guidances, which I know that Sarah and Rebecca talked about previously, they were very easily changed. They could be changed overnight with just a new policy put in place. And that created a lot of instability for individuals filing for the H-1B and other visa categories because there's so many other visas out there as well. So it's nice that this rule, now that it's a regulation, those changes will take a little bit longer to make if they are made, with changing administrations to come.
In H-1B, that really is the primary visa to retain a professional. Basically, the standard is a bachelor's degree and a specialized body of knowledge that's normally required for the field. So this basically will be a solution for these professional positions, professional defined as a bachelor's degree or higher in a field in your workplace.
And that's one of the fun things that this new rule has codified and made into regulation, is when we're talking about that it's a specialty occupation, that means that there's a specialized field of knowledge that's required for this position, and a bachelor's degree is required for entry into this position that provides you with the skill set, that specialized knowledge to complete the job duties of this position. The prior regulations, I mean, this is still in them. The word that they use is that the job and the degree have to be directly related, but it was never defined, and different administrations defined directly related differently. So now there's an actual definition, and that will be that there has to be a logical connection between the degree and the job duties of the position. And it's not just the title. They're not really just looking titles. They're really looking at the duties and the coursework that is being taken for these positions. A fun one that we worked on recently that this really applies for is, for example, supply chain positions. Logically, obviously, a supply chain degree fits, but there's different degrees that also work that provide you with that skill set for those positions, such as industrial engineering or business analytics or similar. And now, as long as we can prove that logical connection between the degree and the coursework and the position duties, there's no issue, whereas different administrations apply that rule differently. So something really nice that has been codified in the regulations now.
So that helps increase chances of success in getting these cases approved.
Yes, hopefully that's what we'll see.
Another great feature is in this new regulation, the standard, the policy of deference, meaning respecting what the previous adjudication outcome was, that is now in the regulation. So if someone was on an H-1B before, for example, and it's being renewed, there's going to be deference to what the previous adjudicator found, unless there's some material change or there was error or new information. So that really helps stability and predictability.
And that has really been a back and forth, I feel like, with the administrations, whether they're applying this deference policy. And something that we saw when it got rescinded is processing times went up because each extension had to be looked at completely all over again. Whereas now they're really looking at those important portions to see if there was material error. And if there wasn't, those cases have this deference applied to them that they should be approved. So hopefully processing times, I know that's something that my clients ask me all the time with a changing administration, is whether processing times will increase. So hopefully the deference policy does keep them pretty stabilized. And Lee, I know there's some other portions of the modernization rule that you're very excited about. With your background in education, you talked about the cap gap.
A great new feature within this regulation, and what it does is it provides expanded cap gap coverage. So oftentimes in the workplace there's international students who are working in a position, and if they get selected for H-1B, then they can have their optional practical training work permit basically automatically extended during the gap period from April 1st, when the filing period starts, till October 1st is when the H-1B work authorization starts. They automatically get their work permits extended. But what cap gap did is it gave them an additional 6 months in case their cases are still pending. It ensures that they can still work in the workplace and not have to sit on the sidelines unpaid waiting for their H-1B to be approved. So this is a great win for employers and students alike, because they can stay productive and stay in their position, because the cap gap coverage is going to cover them even past October, all the way to the next April 1st if their case is pending.
Right, so a very welcome change, even if there is any increase in processing in the new administration, and just going forward in general. I know another one that we've talked about a lot was the owner petitioner.
Surprising good news for H-1B founders. So if someone wants to start their own business and work in their business and also be the beneficiary, this regulation clarifies that you can be a business-owned beneficiary. You can own your own business, and you can apply, basically your company can sponsor you in a specialty occupation, provided that your role is, you're still doing your specialty occupation. So let's say it's an engineering company and that's your background. You're going to be working in engineering the majority of the time. So that's 51% or more, but then you can spend the rest of your time doing the other functions of running the business. So this is a great opportunity for entrepreneurs, and this is now in the regulations. So we expect to see H-1B founders applying in this season as well.
Right, which was really exciting. It'll really promote entrepreneurship in the United States. So I definitely think it's a great addition to the regulations.
And where this is new, some of the parameters that were put in place with it allows for an initial 18-month petition and then extended on another 18-month increment, a little different than the H-1B program, which is 3 years and then renewable for another 3 years. So
yes.
But it's a great new addition and another opportunity for entrepreneurs.
Right, like we mentioned, there's a lot of great additions. I know, one of my favorite is it goes beyond the cap lottery. So for employers that are cap exempt, so employers, for example, hospitals, which I worked with quite extensively, may be cap exempt if they meet certain exemptions in the regulations, one of them being they have affiliations with a university. This is also great for schools. Well, there's another exemption that's actually mentioned in this modernization rule for research institutions, so nonprofit research institutions or government ones. Previously, the definition was that they qualify if they're primarily engaged in research, but this modernization rule changed that to make it that they have to be now have research as a fundamental activity of their organization. So they can be providing other services to the community, but as long as research is also a fundamental activity that they do, they can qualify for this exemption, which is expanded from what it was before, and more entities might qualify.
This can also greatly affect other CAP exempt petitioners. So basically what this means is sometimes if you qualify in a category that you don't have to go through the lottery, you can skip the lottery altogether. Right. So there's like 4 classifications of employers that they don't need to apply in the lottery and get selected against the cap during this certain period of time. They can skip it and apply for H-1B at any time. And so that's higher education, institutions affiliated with higher educations, government research institutions, and then also nonprofit research institutions. So a lot of times clients ask the question, well, do I qualify in any of these? And sometimes they do and they don't even realize it. And so they have expanded accessibility to this visa program without having to apply in April and be selected against the cap.
You were telling me about a case that you had out in California for a teacher shortage.
Yes, absolutely. So what we can do is when there's a teacher in K through 12 who needed a work visa and the employer thought, well, I can't solve this. Well, they actually could. Even though they didn't apply in the cap, they didn't need to because they're a K through 12 school. So they have naturally affiliations with higher education because the teachers go and do training in the K through 12 classroom. So these affiliations exist. So all that had to be done was just point to that existing affiliation, completely bypass the H-1B lottery, didn't need to apply in the H-1B lottery, apply anytime, it's cap exempt, and just file an H-1B petition and solve the work authorization issue and have a work visa in about 3 weeks.
So remind me, in this case, was there an agreement in place, or did you create an affiliation agreement based on the already existing relationship?
That's a good question. There's already an affiliation in place, but even in cases that if it's not memorialized on paper, it could be put on paper what is existing already with the relationships with teacher training and internships and so forth. But most of the time I find these agreements do exist in writing. It's just a matter of the school officials going through the documentation and saying, oh, here, I think I found the agreement. Is this it? Will this work? And yes, that can be enough to show that educational affiliation. Then bypass the H-1B cap, file as a cap exempt eligible employer, and with premium processing can get the H-1B adjudicated in 15 business days.
Yeah, and I've also had successes where there wasn't that affiliation agreement, which is why I was kind of curious about this case. As long as the relationship exists and the agreement is put into place before filing, those cases also qualify for the cap exemption.
Right, helping employers put into writing with what's already legitimately existing. Exactly.
I get that question all the time from students and employees, whether employer they're looking at is cap exempt. And it's hard for us to answer, but that would be something good for an employer to know and provide to certain employees as well.
There's expanded eligibility and some new benefits in this regulation. It also has some additional responsibilities. There's the expectation of having to produce the underlying documentation to support the petition, and that's where employers can really make good use of their time by reviewing their job descriptions in advance and assessing now so that they have passports ready, credentials ready, because really the H-1B is a 2-part analysis. It's is the position fitting with specialty occupation? What does the job description say? What are the requirements? And then also the candidate that's filling the position needs to also have the credentials in the requisite field. So we are always here to help any of our clients and any new prospective inquiries and international students alike. So we hope this information is helpful to you, and feel free to reach out if we can be of further service.